This is the Brave New Coin Crypto Conversation, hosted by Andy Pickering.
Hi everyone, Andy Pickering here. I'm your host and welcome to the Crypto Conversation, a Brave New Coin podcast where we talk to the people building the future in the Bitcoin, blockchain and cryptocurrency space. My guest today is Matt Savare. Matt is a partner at the legal firm Lowenstein Sandler, where he is actually also the chair of commercial contracts. Because Matt is a lawyer, he's a legal guy, we do have to have a little bit of a disclaimer at the start of the show. I'm going to read it now. So I would just like to inform you, dear listeners, that the information provided today is intended for a general audience and is not legal advice or a substitute for the advice of competent counsel. Prior results do not guarantee a similar outcome. The content reflects the personal views and opinions of the participants, and no attorney-client relationship is being created by this podcast. And finally, folks, all rights are reserved. So with that legal disclaimer out of the way, welcome to the show, Matt.
Thank you, Andy. Great to be here.
Great to have you here, Matt. So look, to start with, let's do what we always do. Love it if you could please introduce yourself. Love to hear a little bit about your background, how long you've been a lawyer, and how long you've been with, I guess, Lowenstein Sandler, and what, a little bit about the firm as well.
Sure. So I'm, as you said, a partner within Lowenstein Sandler. I was a summer associate as a second-year law student in 2002. I started full-time with Lowenstein in 2004. Since then, I have focused primarily on intellectual property, commercial contracts, and blockchain. Luckily, a client of mine back in 2009, 2010, right when the Satoshi white paper came out, he was a cryptographer, still is. I think he owns an island somewhere at this point, but he mentioned to me in 2009, hey, you got to read this paper on Bitcoin. It's going to revolutionize a lot of things, including fintech, which I've done a lot of fintech over the years. And I read the white paper. Admittedly, although I'm a technology lawyer, there was some stuff that was a little bit over my head. Spoke to him about it, learned more about it, and each couple of months he would call me up and say, "Hey, did you buy any Bitcoin yet? Did you buy any Bitcoin? It's 20 cents, it's 40 cents, it's $1." It's and that would go on for a period of time. And I am an investor in Bitcoin and Ether. Unfortunately, I did not get in at the time frame that he advised, but I do own some shares and or some tokens, I should say. And I've just followed the industry since 2009, helping him out. And I'm sure we'll go over during the course of the podcast over the last 13 years. We've seen a lot of work in this space, all the way from initial coin offerings a few years ago to NFTs now, SAFs, simplified agreements for future tokens. There's a lot of different flavors that have come up over the last several years, and our firm has been involved really in all of them. A little background on the firm: we're about 350 plus attorneys nationwide. We have offices in New York, New Jersey, Palo Alto, California, Utah, Washington, D.C., and some satellite offices throughout the country. Mid-sized firm, full-service firm for all corporate issues. As I said, my focus is primarily on intellectual property issues. I worked for the government for 7 years for the Department of Defense. So any government contract work that comes in for our clients, I typically handle that as well. So I get to see a good cross-section of different issues.
Fantastic, Matt. Thank you for that. And I should point out to the listeners that the reason, I suppose it is the reason we're talking to Matt today is that Matt and I think one of your colleagues, Matt, you guys published, or you wrote an article that we published on a Brave New Coin, and it's called A Haystack and a Hurricane of the Legal Risks of Depicting Real People in your NFT. So yeah, obviously there's a kind of a bubbling undercurrent around the legalities, shall we say, of different aspects of the NFT ecosystem at the moment. So look, we'll get to that very soon. Matt, I find it fascinating that you've been, I suppose, following the crypto space in one way or another since, I think you said 2012, and you even have some Ether and Bitcoin. You're obviously a fairly accomplished tech lawyer. So how familiar then with the kind of the wider cryptocurrency and blockchain space are you? And also, is there one thing that occurs to me, I don't know if this is an aside or not, but I've seen some journalists, like I think Nathaniel Popper at the New York Times comes to mind. He's, I don't know if you're familiar with his work, but he's written about Bitcoin for the New York Times for a number of years, but he just left the paper very recently. And while he was at the New York Times, he was not able to invest or even really interact with the crypto ecosystem because the New York Times saw that as a conflict of interest. I guess my question is, how does your legal firm kind of balance out that potential conflict of interest, or is there none? And also, just how closely you're following this ecosystem?
Following the ecosystem very closely all the way back from 2009. Again, there are very heavy periods, and then there are some, crypto winter periods where maybe the work is not as active. Right now, we are incredibly active. In 2018, we got to an inflection point where a variety of groups within the firm were doing work within crypto, blockchain, whether it be our tax folks or our patent folks, right? We've done a bunch of patents in the blockchain space, a lot in the fintech area. I've done a lot of work in the intellectual property and commercial contract space. Blockchain is built on open source software, so we have open source software expertise. And we just had a lot of clients that were either directly involved in the industry or immediately ancillary to the industry. So in 2018, we formed our blockchain technology and digital assets group. I was one of the first in the nation to do so. We have about 30 attorneys within the group, ranging from all of the areas that I just discussed, plus, obviously securities law is a big issue, tax, IP, all of the subjects that I went over. So what we did was we really marshaled our assets and said, okay, there's a commonality across a lot of our practice areas. A lot more clients are doing blockchain and crypto work. So let's really have a group that's dedicated to that. So you asked how extensively I'm involved in the ecosystem. I would say I'm very involved in the areas where I specialize. I am conversant with securities law as it relates to blockchain and cryptocurrencies, although I'm not a securities lawyer, right? We have a whole group that does securities law. We also do KYC and AML, that's know your customer, and anti-money laundering. That's another large aspect of this area. So I find it fascinating. I mean, this is one of the few areas where there are so many different disciplines that are impacted within this space. And I have a expertise in a small sliver of it, but my partners and colleagues, you mentioned Brianne Polito, she co-wrote the piece with me. She's in our IP and commercial contracts group. We've got 15 of us just in the commercial contracts group. And we're all up on these issues, and these are emerging and highly evolving trends and issues. If you asked someone in 2016 what an NFT was, they didn't really exist. But I guess they did in a certain form, but they weren't called NFTs. It was really in 2017 when the first CryptoKitty came out, where that was sort of NFTs were then on our radar. So since 2017, we've done a lot more work with NFTs, and I can get into some specifics, at least for clients that I'm allowed to talk about. There are literally a dozen projects right now that I'd love to talk about, but unfortunately they're not dropped yet, they're not released, and I'm not authorized to talk about them publicly. But there are a few that we can talk about, and some of the issues that we've handled.
All right, well, let's do that, Matt. And obviously, I do want to get to the piece you guys wrote for Brave New Coin, but I'm very interested if you can, tell us about one or two examples of cases that you're currently working on that you can talk about. And are these like proactive cases in that a project that's developing some kind of NFT project, they would come to you for a specialist legal advice? Is that how this would work?
So sometimes clients will reach out directly to me because I've written on the subject, I've spoken on the subject, and people just know me in the ecosystem. So sometimes people come directly to me. Sometimes I have clients of my own that start doing NFT work and they know that I do intellectual property, so they will come to me. So new clients come directly to me, existing clients of mine come directly to me. And then there are other clients that have been clients of the firm for over a decade. Here's one example. So Estee Lauder, huge public company, obviously everyone knows who they are. They recently did their first series of NFTs. And they look to Lowenstein Sandler to help them with a lot of the issues, IP issues, security issues. We also worked with a fantastic firm in the UK. So any UK listeners out there, I'll give a plug to our friends at Shoesmiths. They helped out as well. And can't get into all of the stuff that Estee Lauder is doing, but I can certainly talk about the public ones. They did a series of NFTs called Day of Pink, which was a fundraiser for breast cancer awareness. And we handled the intellectual property issues around the commissioning of the artwork. We handled the securities issues around the NFT drop, the contracts with Suite, which is the platform that it was released on. As everyone that's listening, I'm assuming that your audience is fairly sophisticated, so they know what OpenSea and Suite and Consensus, they know the different platforms and consultants out there. So we had to engage. Although Estee Lauder has wonderful technical expertise, they needed some help with their first NFT work, so we did those commercial agreements with their vendors. And that's one example of an existing client that was just starting to get into NFTs. Then we have other clients. We were recently engaged by a company called Magic, and they have a non-custodial wallet that they do. So they have the technology behind the wallet and a lot of really interesting things that are NFT related. It's not an NFT, but it's a technology for people to have passwordless non-custodial wallets. So that's an interesting client that we're working with now. Another one that I think is really exciting, and this sort of takes us out of the world of CryptoKitties and Beeple and artwork and brings it more into the real world. But we have a client called Bacchus, Baxus, and what they do is they will authenticate wine and spirits, and you can buy, trade, and sell alcohol. So they tokenize the spirits on the Solana blockchain. So that will give a certification of authenticity, and then you can track ownership and the provenance of the spirit wine and spirits on their platform. So we're working with them. They're very similar. I don't know if you've heard of Block Bar, but they're very similar to Block Bar and WIV, which does that for wine. So they focus on NFTs in the real world, which I think is going to be a very, very important emergence and evolution of the industry, so to speak, is going from the purely digital and bringing it into the real world and tokenizing real world assets. I think that's going to be a huge thing in the coming years.
Yeah, I think you're exactly right, Matt. And I have heard of Blockbar. I have seen what they're doing there. Yeah, as you say, they're tokenizing, fine whiskey essentially, and other high end liqueurs and spirits and so on. And I think that's definitely going to just accelerate and explode that trend of tokenization of everything from spirits to high end art pieces, real estate, and all sorts of digital and real world items. Let's just dive into this article that you guys wrote, and listeners, it is, as I say, published on Brave New Coin. I'll put a link in the show notes. The article is called "A Haystack in a Hurricane: The Legal Risks of Depicting Real People in Your NFT." So I think to begin with, Matt, why don't you just give us a bit of some background to this piece? What was when did you guys decide to start writing it? And I guess was there kind of an instigation event, anything that you were sort of watching that made you decide to dive into some of the thorny legality issues in the NFT space?
Sure. So I've written and spoken on the right of publicity since 2004 when I was in law school. I wrote, it was either 2 or 3 law review pieces for UCLA Entertainment Law Journal. I went to Seton Hall Law School, and unbeknownst to me, it was frowned upon to publish at a different law school while you were in law school. So I found that out the hard way. But anyway, I published 3 pieces with UCLA, and all 3 related to the right of publicity, which may be foreign to some of your listeners. So I'll give you a little background on what that is and what that means. Most people have heard of, they may not know exactly what it is, but they've heard of copyrights, and they've heard of trademarks. Maybe they've heard of trade secrets, but a lot of people don't know what the right of publicity is. And sort of at its essence, what that means is it's the right of individuals to commercialize their persona, right? The commercial value of their persona, which is their name, their image, their likeness, other indicia of their personality. So there have been cases involving sound-alike people, right? Where Tom Waits has a very distinctive voice, and a brand wanted him to do a commercial. They wanted him to do a song over the commercial. He said, no, I don't do advertisements. So they went and hired a sound-alike, and Tom Waits sued for violating his right of publicity, saying, so it wasn't a copyright claim, it was a right of publicity, saying, you are trying to trade on my voice, right? I have a very distinctive singing voice, and you're now trying to emulate that voice and sort of free ride off of my personality. And he sued and he won. So I've looked at the right of publicity from a variety of different angles. I've looked at it in the pure advertising context, in product placements within feature films, how to value the right of publicity if it's ever infringed. So I've been looking at the right of publicity now for almost 20 years. I litigated for 7 years as well. And when I litigated several right of publicity cases, both for the plaintiff and for the defendant. So it's just something that I've been involved in for a really, really long time. I'm an expert in the field. And then as NFTs started to really, emerge in the last several years, you're starting to see litigation around NFTs. So Miramax just sued Quentin Tarantino for Quentin trying to create NFTs based on handwritten scripts for Pulp Fiction. So Miramax sued him for breach of contract and also copyright infringement. Nike has recently sued someone who's created NFTs regarding their sneakers. So that's a logo trademark dispute. What I haven't seen yet, and I only say yet because it's going to happen sooner rather than later, is there's going to be a lawsuit regarding someone who is depicted in a collectible or in artwork or something that becomes tokenized and put on the blockchain. And I think it's important, again, your audience is sophisticated and they're probably aware of this, but the NFT is not the artwork. It's not the same thing as the artwork. The NFT is really the cryptographically secure record or unit of data. It's really metadata stored on the blockchain that verifies your rights to something, right? You may own that piece of digital art, or you may only have a license to it. Some people think, oh, okay, I bought an NBA Top Shot moment. I own that moment. Well, if you actually read the Dapper Labs terms of use, you don't own the moment. You have a license, a non-commercial license to display and to use that NBA Top Shot moment, right? So some people think, okay, well, I bought an NFT, I quote own the NFT. Well, you may or you may not, right? It might be a license, it might be ownership. So I think that's an important point that I wanted to sort of lay out. And we didn't really dive into that in our article, but I think that's a distinction worth noting during this podcast. So the point I'm trying to make is, if someone is depicted in the artwork or in the collectible that is then tokenized through the NFT, that the individual that's depicted may argue, okay, well, you are exploiting my name, image, or likeness for profit. And if you don't have my permission to do that, you're violating my right of publicity. And we've seen, I don't want to be hyperbolic, but I think that we've seen literally thousands of right of publicity lawsuits over the years involving, and we went through some of the examples in the article, anything from video games to posters and artwork and trading cards, right? Like you name it, and a celebrity has sued over it. And it's not just celebrities that have a right of publicity, it's really any individual. So if you are depicted in something that becomes an NFT and you didn't give your permission, you may actually have a cause of action. So we thought, okay, well, I've done right of publicity now for almost 20 years. I've written almost every conceivable angle on it. The one angle that I haven't written on, and there were very few legal articles about the right of publicity in NFTs. So I figured, all right, well, now's a good time to do it, because you're starting to see lawsuits around other kinds of IP like copyrights and trademarks. So let's throw our hat in the ring.
Fantastic. Oh, so many good thoughts there, Matt. And look, one thing I want to touch on that you mentioned is, you're exactly right. This idea that it's particularly, I think, NFT collections by the more established global, even corporate brands. You use the example of, I think, NBA Top Shot. When people are buying those kinds of NFTs, they're really just buying a digital collectible. They don't really have any commercial rights other than just buying a simple digital collectible. But I think what's really exciting about the potential of, I think, what people call Web3, and maybe the metaverse, but it's really Web3 and the kind of some of the more interesting open source, decentralized Web3 projects that are putting out NFTs that give the user full commercial rights to those NFTs and the kind of the future content that they can create from those NFTs. But it's all that stuff is kind of on the bleeding edge of I think copyright and content and Web3 and technology, and be exciting to see all of that play out. But one thing that also occurs to me, Matt, and the piece you talk about, this idea of right of publicity and how it was once described as a haystack and a hurricane, which is quite a vivid analogy or metaphor. And obviously the current state of NFTs is quite confusing. It's confusing for all of us. It's confusing for brands that are trying to get in, and obviously brands really have to, big corporate entities with public facing brands, they've got to protect themselves. That's why they come to people like you. So what do you mean by a haystack and a hurricane? I mean, I know what you mean, but I'd love to kind of hear you describe it.
So that was coined by a judge many decades ago in one of the leading cases regarding right of publicity. And I don't know the average age of your listener, but I guess the best legal way to describe it would be it's a shit show, right? It's just it is a total mess, right? Because you've got and I'm only speaking from a US perspective, and I have written articles regarding how European nations and other nations throughout the world recognize the right of publicity. Some call it persona rights or image rights or publicity rights. There's different names for it. Some countries recognize it, some don't. But within the United States, and we go a little bit of this in the article, some states recognize it, some don't. Some recognize it by statute, right? A law that's written down. Some recognize it by common law, which means that the courts decide a case and the courts essentially write the law. So it's not a statute, but it's a law that's developed by the courts. So some recognize the right of publicity by statute, some by common law, some by both. Some recognize certain elements of a persona, like name, image, and likeness. Others recognize literally anything that could evoke a person, right? It could be their voice. It could be their uniform number. It could be the insignia on their NASCAR. There's a bunch of different ways that courts and statutes define the right of publicity. Some say entertainment products or news products, there's a First Amendment protection, and that's built into the statute. Some recognize a First Amendment defense by common law, and we'll get into what the transformative use test is and those sorts of things. But it is a very, very complicated area of the law. The cases have been all over the map. California has a very well-developed body of law. New York has one, obviously. They're the two media centers within the US. But there really is a very wide discrepancy between court cases and statutes. And, to try to make heads or tails of it, it's like, a haystack in a hurricane. It's blowing all over the place. You can't put your hands on it because it's blowing all over.
That's right. I love it. And well, Matt, in the article, you say that unfortunately, as of the writing of this article, we are unaware of any court decision that has ruled on whether the depiction of an individual in an NFT without his or her permission violates that person's right of publicity, or whether it is protected speech. And then you say, Matt, that in order to help assess this question, we briefly review some cases relevant to NFTs, ranging from comic book characters and trading cards to artwork and t-shirts. The so-called Transformative Use Test is one of the most widely adopted analyses. So, and you just mentioned this Transformative Use Test a minute or two ago, Matt. So, what does that mean, and what are some examples?
So in 2001, the California Supreme Court ruled on a case called Comedy 3 Products versus Gary Sadarup. It's one of the seminal cases in right of publicity. And in that case, it involved an artist who drew a series of charcoal drawings of the Three Stooges. I don't know if the Three Stooges ever made their way to New Zealand, but they were, they were a while ago, but yep. They were just three dumbasses, right? And they did all kinds of crazy things. And, you look at them and you just want to laugh. I mean, they were just three, real comic superstars. And this guy, Gary Sadarup, said, hey, you know what? I want to draw the Three Stooges. And he drew the Three Stooges as charcoal drawings. And what he did was he sold the drawings as lithograph prints, and then he also sold them as T-shirts. And the estate of the Three Stooges said, okay, well, you didn't, well, in fact, I think he did. I don't know this for sure, but I'm pretty sure that Sadarup asked the estate, can I have your permission to draw them and put them on a T-shirt? And I'm pretty sure he was denied. And he went ahead and did it anyway. I think, don't quote me on that, not like we're litigating on this call, but I'm pretty sure that he asked for permission, didn't get it. Anyway, he released the T-shirts. He was sued by the estate of the Three Stooges, claiming, among other things, that he violated their right of publicity because their faces were depicted on the T-shirt, and that implicates their name, image, and likeness rights, their right of publicity. And they sued. And it went back and forth in the courts, and it eventually got to the Supreme Court of California. And the Supreme Court said, okay, you basically copied their faces. It's a drawing, but it is a very literal depiction of the Three Stooges. You look at them and you immediately know those are the Three Stooges. And Sadarup said, well, wait a second, like I drew this picture. It wasn't like I took a photograph and just, slapped it on a t-shirt. I actually did some artistic rendering, and there's some shading, and, it's in charcoal, it's in a completely different medium. And the court basically said, no, in order to get First Amendment protection that would override the Three Stooges' right of publicity, right? The right to protect their name, image, and likeness, you need to transform their depiction. And what does that mean? So the California Supreme Court, again, out of nowhere, this had never been decided in a right of publicity context. It's borrowed from a copyright context, which it's sort of beyond the scope of this podcast, but it's a concept that's borrowed from copyright law. And the court basically stated that you have to look at whether the work adds any significant creative elements so that the likeness is transformed into something more than just the mere celebrity likeness or imitation of them, right? So they said that a product is, quote, transformative and protected by the First Amendment if it's transformed in such a way that it becomes primarily the defendant's own expression rather than just a depiction of the celebrity's likeness. And they said this was a literal depiction. It wasn't transformative enough. Sorry, Gary, you lose. And since then, a variety of courts, California, obviously this is now precedent in California, so any state case in California has to follow this precedent. The Ninth Circuit, which covers, so that's a federal court within the California region, so any federal case in the California area now follows this. The Third Circuit, which represents, among other places, New Jersey, follows this transformative use case. So it's been applied in the context of comic book characters. And we discussed that in the article, a case called Winter versus DC Comics, where the Supreme Court, again, applying the transformative use test, said that distorted cartoon characters in a comic book were, even though it was pretty obvious that the author, or I should say the illustrator, borrowed the likeness and the persona of these two plaintiffs, their likeness was sufficiently transformed and distorted such that they were then transformative enough so that they were entitled to First Amendment protection. So we've got, on the one hand, a literal depiction, like in the Three Stooges, that's a no-go in California. However, if you take two people and transform them into half human, half worm characters in a comic book, that's transformative enough. Then you've got, again, it's all over the map, Andy. Another one is there was a painting that was made. This is on Tiger Woods. So there was a painting titled "The Masters of Augusta." Again, we talk about this in the article. And the painter did a rendering of Tiger Woods winning the Masters. He's pumping his fist. And there are some other well-known golfers in the art print, and the court ruled that it was sufficiently transformative, even though you look at it and you think, wow, that's Tiger Woods. There was enough other things. It wasn't just a literal depiction of Tiger. There were other golfers there. They show a little bit of the course. They show Augusta, right? So that was found to be transformative and protected by the First Amendment. I think the one that I think is probably the most on point, or one of the most on point, is another case that we talk about in the article called Cartoons versus Major League Baseball Players Association. So Cartoons, what they did, they created parody baseball trading cards. So they made the images of real players, real statistics, real everything, right? They used, factual information about the players' statistics, but they made them almost like, I don't know, again, if this ever made its way down to New Zealand, but back in the day, they had garbage pail kids. And I remember one of my teachers when I was growing up, she gave me a card and it was of an obese child and it was called Fat Matt. Her name was Margaret, so I gave her a card called Large Marge. So she returned the favor by giving me a Fat Matt. But anyway, it's a gross, caricature of a person, which is what cartoons did. They created these parodic cards, and the court found that the parody was protected as free speech because, again, it's sufficiently, I don't know if that was necessarily a transformative use analysis, but it's along the same vein in that you have a First Amendment protection if you do something beyond just using their name, image, or likeness. And the last case that was not in the article that I should point out is there have been a lot of cases around video games. And one of the most famous cases was involving a former Rutgers quarterback. His name was Hart, H-A-R-T. And he sued the NCAA and Electronic Arts for a college football game that depicted him in the video game. And he alleged that, he didn't give his rights for the NCAA or EA to make this video game. So his depiction in the video game, obviously you look at him, it's the Rutgers uniform, it's the Rutgers uniform number. It looked just like him. I mean, if you play any of these games, my son plays the Xbox, and I walk down into the basement and I'm like, oh, I didn't know the Knicks were playing. And he's like, no, I'm playing the video game. I mean, it's like identical to real world action here. So Hart sued and said, you've misappropriated my name, image, and likeness. You used my name in the game and you're using my likeness. And he sued for violation of his right of publicity, and he won. And then it went back and forth up and down the courts all the way to the Third Circuit, and the Third Circuit upheld the verdict for him that said, and EA said, no, we transformed his likeness because we put it into this huge video game, right? I mean, there were thousands of hours that went into creating this amazing video game. He's like a little piece of it, and they lost because the court ruled that it wasn't sufficiently transformative enough. So again, it's all over the map, and it's kind of like Forrest Gump said, it's like a box of chocolates. You never know what you're going to get.
Yeah, that's exactly right. It is all over the map. Excuse me, Matt. And I love I love that you brought up the garbage pail kids. I mean, perhaps we're slightly dating ourselves, and that yeah, I was around, and yeah, I mean, we were both probably kids in the 80s when they came out, and had a lot of fun collecting them, sort of, yeah, getting bubble gum stuck in your hair and all that good stuff. And did you know that, yeah, Garbage Pail Kids, they're actually still around, and funnily enough, they're now released on the Wax blockchain, so you can get interactive, yeah, You can look it up. They're interactive Garbage Pail Kids on the blockchain. They're still around, still produced by Tops. But
that's
just
amazing.
It is amazing.
Andy, that might be my first NFT. I may have to buy Fat Matt just for old time's sake.
There you go. Speaking of the the transformative use case, and it does make sense, but it just kind of occurs to me. Lamborghini, right? So obviously, as a crypto guy yourself, Matt, everyone knows I suppose the significance of Lambos to crypto kind of culture in general. It's everyone has the dream of their crypto or NFTs, their trading doing well enough that they can buy in real life Lambo. And funnily enough, Lamborghini have done their own official NFT. But I've also, I'm aware of a few different collections that are using Lamborghinis in one sense or another in their NFT collection. And I don't know, I haven't seen any reaction from Lamborghini. I don't know if they would even pass the transformative use case, because in some cases, they're just kind of photos or kind of really good depictions of a Lamborghini used in backgrounds to NFT collections. What would your take be on kind of Lamborghini's attitude to that kind of stuff? Because in some ways I see that as it's just positive for the brand, really.
Yeah, so you bring up there's a few issues there. The first one is that wouldn't be a right of publicity matter. That would be more of a trademark matter. Yeah. So Lamborghini has a trademark in Lamborghini. There could be a copyright in the photograph that was used. So there could be a whole bunch of different intellectual property issues. what I would say, and the other thing that you brought up is that it would actually potentially reflect well on the brand. So we represent, we do a lot of trademark work. My partner Vanessa Ignacio is fantastic. We have a great trademark practice, and we represent a lot of very large brands and some smaller brands too. And sometimes they take the position that any publicity is good publicity, and as long as it's not being used in a derogatory way, it's not being disparaged, it's not being associated with things that are, things they don't want to associate themselves with, we'll allow it. The only problem is, and I know we're getting away from sort of right of publicity, but what you don't want to do in a trademark context is you don't want to grant what's called a naked license or no license at all. So if you're a trademark owner, you don't want to have people, even if it reflects well on the brand and you're okay with it, you generally want to have something in writing that says, hey, I see what you've done and I'm okay with it. And I'm documenting that you're okay with it. And you have a license to do this. But if I start not liking what you're doing, you've got to take it down. Because if you have a trademark and you allow people to use it without your permission, there could be a finding that you've abandoned your trademark. And then you could actually lose the IP rights that you've spent a lot of time, money, and effort building up. So I don't represent Lamborghini, at least I personally don't. I don't think my firm does. I would imagine that there are attorneys and business folks within Lamborghini that are on this, and they either have licensed the right to use Lamborghini or have sent demand letters telling people to stop using the Lamborghini, or they're in discussions. You and I haven't talked about it, but I mean, we've exchanged some emails. There is rampant trademark infringement, copyright infringement, violation of the right of publicity. Yeah. In the States, we have something called whack-a-mole. I used to work in an arcade, and the whack-a-mole was, yeah. Right? It's a big box, and it's got, 9 holes, and you get a little hammer, and a mole will pop up out of each of the holes, right, at different times. And you hit it down with the hammer. You hit one down, another one pops up. And trying to stamp out infringement, whether it's copyright infringement, trademark infringement, violation of your right of publicity, whatever it is, it's like whack-a-mole. You hit one down, another one pops up somewhere else. So a lot of times brands focus on the bigger ticket infringements. They will go and approach the platforms, right? Like OpenSea. I understand that OpenSea has a policy for intellectual property infringement, just like all platforms do, that says, okay, if your IP is being infringed, let us know and we'll address it. But even for them, right? It's the same thing for YouTube. When YouTube first started out, they were getting tens of thousands of takedown requests and demands. There's a huge lawsuit with Viacom for having all of the, there was certain content on YouTube that wasn't being taken down quickly enough. And there was a huge lawsuit whether or not YouTube could be responsible for stuff that its users uploaded to the service. So it is a constant battle. And the other part is sometimes the brands will be overly zealous in protecting their IP. There might be a fair use in a copyright context, or a transformative use in a right of publicity context, and you have to balance. You have to sort of balance public perception and your IP rights, because you don't want to come across as being draconian and killing. If someone's doing like a fan type engagement, and they're doing it as in honor of the brand, you don't want to draft a 10-page demand letter that makes the brand look like a bunch of dragons, right? You want to be sympathetic to your audience, but while at the same time protecting your IP in a sensible way.
Yeah, I think that's a really good way of putting it. In the case of Lamborghini, yeah, I think it'd be a mistake for them to come down too hard, because it would just be the backlash to the brand would be considerable. And I mean, I obviously can't speak for them, and I know you can't either, but I just think it would be a lose-lose situation for them, unless there was someone was actually trying to make money specifically off their brand. But I just, look, I'm conscious of time, Matt. There's just a couple of things I want to get to, and I do want to do the very famous Crypto Conversation hot take around with you, because I think that'll be fun. I want to just touch on Mr. Tarantino, who we did mention briefly. Also want to touch on Beeple, because Beeple, obviously everyone will be aware of, who Beeple is and his NFTs. Maybe they're less aware of the kind of the art that he does as part of his everyday project, but as part of that project, he's done all sorts of really out there art. I'm sure you've seen it, Matt, depicting public figures, everyone from Donald Trump, Kanye West, Jeff Bezos, people like that, Kardashians, and he depicts these people in really surreal and grotesque imagery and environments. I guess it's kind of like a cartoon. It's kind of like a garbage pail kid cartoon. Really, it's just a kind of extension of that kind of style. How do you see, would the likes of, if Donald Trump or Kanye West or Kim Kardashian, someone like that, took offense to the way they were depicted in a Beeple NFT, would they have any grounds, do you think?
I think people's work, and I'm not familiar with all of it. I'm familiar with sort of the concept of it. I've seen some of it, but I know he's prolific and he's done a whole bunch of stuff. But you're right. It's typically distorted, grotesque, however you want to frame it. It is not a photograph of any of those people, right? It is, I think, sufficiently transformed. So from a purely right of publicity perspective, I think he's in the clear.
Yeah.
That doesn't mean that they can't sue him or send him a demand letter. He may have already received one. I have no idea. But there are other causes of action that they could potentially allege, right? They could allege, I don't know if there's ever been a case of defamation through artwork, but there are certainly defamation claims that if you depict someone in a false and defamatory manner, there could be a defamation claim. Like I said, I've never seen that in artwork. I think it would be a really hard burden. And in the United States, there's something called actual malice, which you would need to prove, which means that it was either you knew that it was false or you had a reckless disregard for whether or not it was false. So I think those kinds of causes of action would be unavailing as well. And then maybe like the third thing that you could possibly allege would be if Beeple were to in some way depict a copyrighted image within his work, right? So that there could be theoretically a copyright claim. But again, the concept of transformative use really comes from the copyright world regarding transforming a copyrighted work into something that really becomes your speech and your work. It's sufficiently transformed. So I think in all of those, Mr. Trump, Mr. West, and Ms. Kardashian, I think they're. I was going to say I think they're all losers, but they're all losers for this particular case. Let's leave it at that.
Yeah, in my mind, it's not really any different from appearing in Mad Magazine. It's just the same kind of thing. I said we'd talk about Tarantino because this is kind of. I'm not too familiar. I'm kind of familiar with the case, but you can probably describe it slightly better than I can, Matt. So maybe do you want to just give us a very quick summary of what's happening with the Tarantino case? And I'm not sure if that case has gone to trial or if it's being settled out of court or exactly how or what the outcome is there. Maybe you know as well. What's happening with the Tarantino case?
All I know is what's publicly available. So I probably know just a little bit more than you because I've read up on it. So people are probably familiar with the movie Pulp Fiction, fantastic film from '94. So Tarantino, allegedly, again, I don't know any of this to be factual. I'm just saying what I know from the papers, took several copies of his screenplays, various versions of it, whether they were handwritten or early versions, with crossouts, and I couldn't even imagine what an early edition of a Quentin Tarantino script would look like. But anyway, he put those up as NFTs, and Miramax sued him, saying that he breached their contract, which presumably, and I do some entertainment work as well in the film and TV industry. and usually when someone acquires a film, they acquire everything. They acquire all versions, you know, rough cuts, whatever, they own it. So they presumably argued that when he signed up with Miramax, that Miramax owns everything, whether it's the final version of the script or the first version on his Commodore 64, whatever it was, right? We own it.
Yeah.
And he released the NFTs anyway, and they sued for copyright infringement, claiming that they own the copyrights, and for breach of contract, claiming that he violated whatever contract they have together. I would say that this will never go to trial. I'm just making a prediction. It was just recently filed. These cases usually are more of posturing and leverage. And it's not like Miramax just sued him. I'm sure there were letters back and forth, angry phone calls, yelling, screaming. You know, hopefully Mr. Pink didn't need to get involved. But that's a Reservoir Dogs quote for any Tarantino fans out there.
Yes.
So this will not go to trial. This will settle at some point. It does not involve the right of publicity, but it is one of the things that's on my radar because it is an intellectual property / contract claim arising from an NFT. And as of now, I just checked before, you know, we went on the air at 3 o'clock here. And as of 3 o'clock on February 23rd, 2022, the case has not moved at all. So if it ever goes to trial, which it won't, it'll be years before it sees a courtroom.
Yeah. And I guess lastly, Matt, I'd love to get some general thoughts from you. So, you know, I guess one of the themes that we've identified here is this idea of a haystack and a hurricane, and that, you know, and also this game of whack-a-mole. And it's just there's so much going on. It's very hard to keep abreast of it. And I think, you know, kind of talked about this before. One of the promises of Web3 is getting away from, no disrespect to your good self, Matt, or your firm, but this idea of kind of getting away from middlemen, whether it's kind of record companies, movie companies, or expensive legal firms, right? You know, it's kind of putting the power back into the, you know, the individual creator, giving the small independent artist a means to promote themselves and earn a living from their art without having to, just, you know, pay all these different intermediaries. But at the same time, of course, you know, the flip side of that is, just because NFTs are so new and potentially so lucrative, as you know, there are so many scam artists in the place and bad actors, and people will try and rip off artists by, you know, posting them on OpenSea themselves and you know, trying to sell NFTs off the back of someone else's creative output. I don't know how any of this is resolved, but and I'm sure you don't either, Matt, but I guess just to kind of finish off, what do you see, any sort of trends, or what do you think, are there any legal ways we can kind of resolve any of this, or is the technology, as I suspect, it just moves too fast? But yeah, is there a way forward? What do you think?
I think I'm dating myself again, but I think this is very similar to when Web 1.0 was released, and then Web 2.0, right? We saw this with Napster, right? The laws are in place, but the law is always catching up with the technology, and we're seeing that now in the blockchain space as well, right? The old laws for securities do not work in the blockchain world. It just does not work for 3.0. And I know we're not talking about securities law here, but intellectual property law, it's always important when it's your IP. You know what I mean? So some people say, well, you know, I want to create, I want to borrow, I want to be able to do all this stuff. And then someone infringes their IP and they say, oh, but we got to protect mine. So I think there is an element of a balancing act. And just for the record, I am all for disintermediation as well when the intermediaries are not adding value. So I'm a huge fan of being able to go creator directly to the fan base. I think it is, NFTs and blockchain is an incredible way to create a deeper relationship and engagement with the user, consumer, fan base. it's a direct relationship, which I think is great. There's, interactive and incredible creative ways that you can do it. So I'm a blockchain bull. I'm an NFT bull. I think we're going to see a lot more tokenization of real world assets. I think it's, right now we're seeing it sort of revolutionize media and entertainment. And I think we're only going to continue to see this. How are ways that we can smooth this over? I think it's a little bit better than the Wild West, but it's still pretty wild, right? And it will eventually get tamed. I hope it doesn't get tamed quite the way the web did, because I think the web now is much more restrictive and not as free as it was envisioned to be. And I don't want to be a doom goblin here, but I think blockchain is going to go the same way, where it starts out unregulated, anything goes, no holds barred, and incrementally we will see more and more restrictions, more and more shackles, more and more control. I hope that doesn't happen, but I do think that there are some parameters within which we need to work. We can't have, as you said, rampant fraud. We can't have OpenSea having smart contracts that are not completed and people steal $2 million in Bored Ape Yacht Club. We can't have that. So it really is a balancing act. And I know a lot of really smart people, much smarter than me, that are invested in the ecosystem, that are trying to advance blockchain, advance the technology, advance all of the social and economic benefits that come from it. And I think, as a whole, we're all rowing in the same direction. And I think we'll get there. I think it's an evolutionary process. And, it's not going to be a straight, smooth line. You're going to have your ups and downs, but I think eventually we'll see some great progress. That's my hope anyway.
All right. Very nice thoughts, Matt. I hope you're right. That feels like a nice place to go to a very quick break, and then we'll come back. We'll finish off. We'll have some fun. We'll do the very famous crypto conversation hot take round.
For crypto indices and benchmarking, Brave New Coin's powerful indexing engine can calculate high-frequency intraday and end-of-day indices for a wide range of index products. Brave New Coin's custom indices team delivers experienced consultancy, premium data, and trusted calculation. Contact BNC today to find out more.
All right, we're back, and I'm with Matt Savare. He's a lawyer and a partner at Lowenstein Sandler. He's chair of commercial contracts. As you've heard, he's very immersed in the crypto and NFT ecosystem, and especially so from a legal point of view. And look, Matt, I like to finish each podcast with just a quick round of rapid fire crypto conversation hot takes. Are you up for it?
I'm up for it.
So no legal disclaimer required here, Matt, but I'm just gonna throw some quick questions at you. It's just a bit of fun. Just want quick, snappy answers, hot take style, just your personal opinions. To begin with, Matt, where would you say that you sit on the Bitcoin maximalist to multi-coin opportunist spectrum?
Well, we said before, I own Bitcoin and Ether. I don't own any other coins, so I would say that probably makes me a maximalist.
All right. What would you say then is your firmest conviction crypto opinion, Matt?
If you asked me 4 months ago, I would have said Bitcoin at 100,000 by the beginning of 2022.
Yep.
Things have changed, but
yeah.
I am not selling a single Bitcoin until it hits at least 250,000.
I love it. All right, Matt, Bill Gates famously said that we tend to overestimate what we can accomplish in 2 years and underestimate what we can accomplish in 10. So look, whatever you like here, but Bitcoin, NFTs, crypto, the legal system, what does it all look like in 10 years' time?
Oh my God. I think in 10 years' time, we are absolutely immersed in it, and I think we will know that point when we don't talk about blockchain or cryptocurrencies, right? It just becomes part of our everyday life. It's just ingrained in everything that we're doing, from finance to voting to health records to wine to art, it's just ubiquitous and it's seamless and it's everywhere. Just like people don't talk about email anymore, or people don't talk about websites anymore. It's just, you just do it. I think that's where we're going to be in 10 years.
Yep, that is a great way to put it, Matt. I like that and I agree. The flip side of that, of course, is, this quote by sci-fi author William Gibson, who famously said that the future is already here, it's just not evenly distributed. In the context of that, Matt, can you think of an example of the future being here right now, but most people just aren't really aware of it?
I think NFTs. Right? I mean, there
Yes.
are people that are in the know and that are making a lot of money and creating art and are part of the ecosystem. And if you talked about NFTs in 2017 when the first CryptoKitty was minted, I think I might have known 5 people that knew what Dapper Labs was or what CryptoKitties were. If you ask people now, maybe 10% of the population knows what NFTs are. So I think you've already said it. We're here. The future is here now, but the technology is not as seamless, ubiquitous, and easy to use as it will need to be. I'm a technology lawyer, and there are a lot of things that I understand about the technology, and there are certain things that I don't understand. And things that really should be very easy to do aren't easy to do. And I think as more people make more things more easy, you will have more adoption.
Awesome. I like it a lot, Matt. Time to finish this off. Let's start to close this out. What is your favorite science fiction book, film, TV show, or universe?
The first Matrix.
Nice. Yeah, that's a good one. First Matrix, an absolute classic. Have you seen the new Matrix?
I was gonna say, unfortunately, yes, but it was okay. I'd give it a B-.
Yeah, I haven't seen it yet, but mixed reviews to say the least. Hey, thanks for coming on, Matt. This has actually been a lot of fun. I've very much enjoyed talking to you. Look, please.
I'm very surprised by that.
Please, close it out. Tell the listeners where they can go. If they, I don't know if you're on Twitter or any social media, or if you lawyers do that kind of stuff, but maybe please feel free to give a shout out for your firm, where people can go if they're listening and they think that perhaps they need some potential legal advice for an NFT project or some other crypto endeavor that they may be engaging with.
Sure, I'm on Twitter at Savare, S-A-V as in Victor, A-R-E. I'm on LinkedIn. I'm on the web under Lowenstein Sandler, and you could always reach me via email at msavary@lowenstein.com, LOWENSTEIN.com.
Awesome. Thank you very much, Matt. As I say, enjoyed this a lot. Thanks for coming on. All the best, and bye for now.
Thank you, Andy. It was great fun.
All right. There you go. That was Matt Savare from Lowenstein Sandler. Matt was good. Yeah, he was fun. It's always funny doing, shows with lawyers because they can be lawyerly, to say the least. But yeah, Matt was great. He's a good talker. A lot of fun. So yeah, I enjoyed that. And look, I think it's just, as Matt said, really, it's just it's fairly gnarly out there. All sorts of people doing all sorts of NFT projects. Some skirt the boundaries of what is fair on a copyright case, and yeah, I don't know. I think we just have to see it all play out. Now, I did mention that article, and as I say, we'll put the link in the show notes. It's on bravenewcoin.com, A Haystack in a Hurricane, the legal risks of depicting real people in your NFT. So if you are thinking of putting out an NFT project, that is a good place to start, my friends. Yeah, all right. Hey, thank you very much for listening. Don't forget to subscribe to the Crypto Conversation in whatever podcast app you are using. Please feel free to give us a rating in Apple iTunes or the podcast app. Always appreciate it. Write us a review, all that good stuff. But for now, we're out of here. Thanks, team. This was the Crypto Conversation for Brave New Coin.